day, everyone. We are Group 2, composed of Miss Pilar Pinga-Cruz, Miss Shane Lian de Guzman, Miss Lian Filimon, Mr. Adrian Silvestre, and I, Eileen Balan, to present the different laws relating to education and educational administration, specifically Labor Law, Anti-Sexual Harassment Act, Safe Spaces Act, Juvenile Justice Welfare Act, Violence Against Women and Their Children Act, Anti-Child Abuse Law, Anti-Bullying Act, and Anti-Hazing Law. Under Article 13, Section 3 of the 1987 Constitution, the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. It shall guarantee the rights of all workers to self-organization, collective bargaining, and negotiations. So under this law, the right to self-organizations give workers the freedom to form, join, or assist labor organizations such as unions or associations. These groups can then represent them in collective bargaining, allowing workers to negotiate with employers regarding wages, benefits, working hours, and other conditions of employment. So this right is further reinforced by the Labor Code of the Philippines under Article 253, which encouraged free and voluntary collective bargaining. So, as employers of educational institutions, the teachers are covered by the same labor protections. So, the teachers may form or join unions or professional associations. They have the right to advocate for better pay, fair benefits, and improved working conditions, and entitled to engage in collective bargaining with their employers, whether they work in public or private schools. What is collective bargaining agreement and labor dispute? A collective bargaining agreement is a contract negotiated between an employer and the sole and exclusive bargaining agent of the workers, covering wages, hours of work, and other terms and conditions of employment, including grievance mechanisms and contract execution if requested by either party. So, this is both a statutory and jurisprudential definition in the case of Honda Philippines Incorporation versus the Samahan ng Malayang Manggagawa sa Honda. Also, labor dispute includes any controversy or matter concerning terms and conditions of employment or the association or representation of persons and negotiating, fixing and maintaining, changing, or arranging the terms and conditions of employment, regardless of whether the disputants stand in the proximate relation of employer and employee. So here, the teachers have the right to organize and negotiate of terms under the collective bargaining agreement. So in the right to organize, the teachers in both public and private educational institutions have the right to form and join a labor organizations for purposes of collective bargaining, subject to limitations for managerial and supervisory employees. Negotiation of terms, the collective bargaining agreements allows teachers to negotiate for better wages, benefits, workload, academic freedom, and grievance mechanisms. For dispute resolution, the structured mechanisms for resolving labor disputes provide for teachers and school administrators with peaceful, orderly, and legally sanctioned avenues for addressing grievance and conflicts. Strikes and lockouts. Strikes means any temporary stoppage of work by the concerted action of the employees as a result of an industrial or labor dispute, while lockout means the temporary refusal of an employer to furnish work as a result of an industrial or labor dispute. However, not all workers have the same rights when it comes to participating in these actions. The coverage and limitations vary between a public and a private school teachers. For public school teachers, they are covered by the labor code only insofar as not inconsistent with special laws, such as Magna Carta for public school teachers. As a civil service employees, the right to strike is restricted under the 1987 Constitution and the Administrative Code of the 1987, which prohibits strikes in the civil service due to the essential nature of public education. For private school teachers, Uh, they are fully covered by the labor code, including provisions on strikes and lockouts. They may lawfully strike or be locked out subject to the procedures under the Article 278 of the Labor Code. Republic Act Number 9520, known as the Philippine Cooperative Code of 2008, provides a legal framework for cooperatives in education, promoting democratic governance, professional development, and economic empowerment for educators. Educational administrators must navigate these structures to foster a transparent, accountable, and participatory educational environment. An education cooperative is one organized for the primary purpose of owning and operating licensed educational institutions, notwithstanding the provisions of the RA number 9155, otherwise known as the Governance of Basic Education Act of 2001. Beyond managing schools, the education cooperatives also serve as platforms for enhancing the economic welfare of school personnel. So under this law, the teachers and staff can organize cooperatives to run services such as canteens, bookstores, and supply centers, which generate supplementary income and contribute to their financial stability. These enterprises not only support the daily operations of the school, but also serve as a sustainable income source for educators. Additionally, cooperatives can offer savings, loans, and welfare services, reducing dependence on informal lenders.
Republic Act number 7877, or the Anti-Sexual Harassment Act of 1995, was approved on February 14, 1995. Section 2 of the Act states that the state shall value the dignity of every individual, enhance the development of its human resources, guarantee full respect for human rights, and uphold the dignity of workers, employees, applicants for employment, students, or those undergoing training, instruction, or education. Towards this end, all forms of sexual harassment in the employment, education, or training environment are hereby declared unlawful. Who may be liable for sexual harassment in education or training-related environment? Under Section 3 of the Act, sexual harassment is committed in an education or training-related environment by teachers, instructors, professors, coaches, trainers, or any other person who, having authority, influence, or moral ascendancy over another in a training or education environment, demands, requests, or otherwise requires any sexual favor from the other, regardless of whether the demand, request, or requirement for submission is accepted or not by the object of said act. How is sexual harassment committed in education or training-related environment? Pursuant to Section 3B of the Act, sexual harassment is committed in education or training-related environment in any of the following instances. 1. Against one who is under the care, custody, or supervision of the offender. 2. Against one whose education, training, apprenticeship, or tutorship is entrusted to the offender. 3. When the sexual favor is made a condition to the giving of a passing grade, or the granting of honors and scholarships, or the payment of a stipend, allowance, or other benefits, privileges, or consideration. Or 4. When the sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice. Also, under Section 6 of RA 7877, nothing shall preclude the victim of sexual harassment from instituting a separate and independent action for damages and other affirmative relief. Meanwhile, Republic Act number 11313, or the Safe Spaces Act, was signed into law by former President Rodrigo Roa Duterte on July 15, 2019. The Safe Spaces Act designates certain spaces as those that shall be accorded the legal protection sought to be enforced under the provisions of the Act, stating that it is the policy of the state to value the dignity of every human person and guarantee full respect for human rights. It is likewise the policy of the state to recognize the role of women in nation building and ensure the fundamental equality before the law of women and men. The state also recognizes that both men and women must have equality security, and safety, not only in private, but also on the streets, public spaces, online, workplaces, and educational and training institutions. Under Section 21, every school is mandated to adopt and publish grievance procedures to facilitate the filing of complaints by students and faculty members. Even if an individual does not want to file a complaint or does not request that the school take any action on behalf of a student or faculty member, and school authorities have knowledge or reasonably know about a possible or impending act of gender-based sexual harassment or sexual violence, the school should promptly investigate to determine the veracity of such information or knowledge and the circumstances under which the act of gender-based sexual harassment or sexual violence were committed and take appropriate steps to resolve the situation. Moreover, once a perpetrator is found guilty, the educational institution may reserve the right to strip the diploma from the perpetrator or issue an expulsion order. In an en banc decision of the Supreme Court on April 10, 2019, regarding anonymous complaint against Attorney Crescencio Pico Untian Jr. with AC number 5900, wherein a professor who is also a lawyer was suspended for 5 years from practicing law and for 10 years from teaching law after being found guilty of sexual harassment towards students at Xavier University in Cagayan de Oro City. The facts of the case are as follows. An anonymous complaint against Attorney Crescencio Untian Jr. for alleged sexual harassment of students at Xavier University in Cagayan de Oro City was filed, accusing him of sexually harassing 3 students, namely Antoinette Toyco, Cristina Sagarbarria, and Lea Dal Toyco. Antoinette claimed Untian sent her romantic messages and poems. On the other hand, Sagarbarria stated Untian showed her a lewd photograph and teased her in front of other students. And lastly, Dal recounted an incident where Untian made a sexually charged remark about her during a class recitation. The Committee on Decorum and Investigation or CODI of Xavier University recommended not renewing Untian's teaching contract, while the Integrated Bar of the Philippines Board of Governors initially recommended disbarment but later on reduced it to a 2-year suspension. The issue of this case is whether Untian's actions constitute sexual harassment. The Supreme Court found that Untian's actions constituted sexual harassment as defined by law. Sexual harassment can occur even without a direct demand for a sexual favor. Sexual harassment can create a hostile or offensive environment for the victim. Untian's actions were reprehensible, considering his position as a professor and member of the legal profession. Untian is suspended from the practice of law for 5 years and from teaching law for 10 years, warning that any repetition of similar acts would be dealt with more severely. Now to compare the Anti-Sexual Harassment Act versus the Safe Spaces Act. Under the Anti-Sexual Harassment Act, it is limited to the context of work, education, and training environment. Also, the crime of sexual harassment requires that the offender has authority, influence, or moral ascendancy over the victim. On the other hand, the Safe Spaces Act, aside from work, education, or training environment, it also covers the streets, public spaces, internet, or cyberspace. It also dispenses with the requirement that the offender has authority, influence, or moral ascendancy over the victim. And lastly, the Safe Spaces Act is directly addressed against the commission of harassments that are gender-based.
So at this part of our report, I will discuss Republic Act number 9344, otherwise known as the Juvenile Justice and Welfare Act of 2006. This is a law enacted to protect the best interests of children, particularly those at risk and in conflict with the law, or the CICS.
Aligning with constitutional and international child rights standards, the best interest of the child, as defined in the Act, encompasses all circumstances and conditions most conducive to a child's survival, protection, security, and holistic development, representing the least harmful option for their growth. This principle mandates the schools and educators to prioritize the best interests of the child as defined when offering alternative learning solutions for at-risk and CICL students. So does the Juvenile Justice and Welfare Act apply in school context? The answer is yes. The law specifically mandates schools to be an integral part of the rehabilitation process of children at risk and children in conflict with the law. Section 13 of the Act states that schools shall provide adequate, necessary, and individualized educational schemes for children manifesting difficult behavior and children in conflict with the law. In cases where children in conflict with the law are taken into custody or detained in rehabilitation centers, they should be provided the opportunity to continue learning despite their situation under an ALS or alternative learning system with basic literacy program or non-formal education accreditation equivalency system. Now, how can educational institutions contribute to the Comprehensive Juvenile Intervention Program? Now, under Sections 18 and 19 of RA 9344, it provides that LGUs should lead the Comprehensive Juvenile Intervention Program for at least 3 years. So, this is a program to be led by the local government units, cities, and municipalities with the help of the Local Council for the Protection of Children or the LCPC. Juvenile intervention programs are formulated and designed with the education sector as LCPC member. Community-based programs are also implemented in which schools may contribute by providing learning assistance to children at risk and CICLs and allowing them to receive the quality of education based on their best interest and with due guidance to their families. In fact, the ILG Memorandum Circular that was issued in 2020, it requires that the membership of the school's division superintendent in all LCPC as permanent as well as a parent representative. Now, what is Department of Education Order number 18, series of 2015? Now, this DepEd order provides for the guidelines and procedures on the management of children at risk and CICLs issued on May 18, 2015. This is a measure to strengthen the policies against incidents of violence involving children in the schools, which may include physical and sexual violence, gang-related, fraternity violence, drug and alcohol abuse, and other similar acts. The issuance of this, the issuance also provides for the duties of schools for the CICLs and the creation of a CPC or Child Protection Committee in each primary and secondary school that is composed of school administrators, teaching personnel, even the student representatives, parent representatives, guidance counselors, and representatives from the barangay. Now, under this DepEd order, the role of schools is primarily focused on the protection and of rights of the children, which includes working with families and communities to intensify the crime prevention efforts and prevent juvenile delinquency. They are also responsible for providing adequate, necessary, and individualized, as mentioned earlier, these educational schemes and interventions especially that alternative learning system for those in custody. Now, furthermore, schools are mandated to develop and implement intervention programs for children at risk, train their personnel on restorative justice, and monitor the progress of these children, as well as maintain confidential case records and coordinate with relevant agencies for appropriate assistance and intervention. Now, what is part of this report? I will be discussing Republic Act number 9262 or the Anti-Violence Against Women and Children Act of 2004, which encompasses any act or series of acts by a person against their current or former wife, partner, maybe sexual or dating, or a woman with whom they share a child, as well as against that child, whether legitimate or illegitimate, regardless of the location. Now, RA 9262 provides that violence includes actions resulting in or likely to cause physical, sexual, or psychological harm or suffering, as well as economic abuse, including threats, battery, assault, coercion, harassment, or arbitrary deprivation of liberty. Now, specific examples of physical violence includes that of bodily harm, sexual violence from rape to harassment to exploitation or forced sexual acts. Psychological violence, on the other hand, includes mental or emotional suffering through intimidation, stalking, humiliation, and verbal abuse, and even witnessing abuse of family or pets. Economic abuse, on the other hand, aimed at financial dependence through withholding support, deprivation of resources, property destruction, or controlling finances. Aside from the different kinds of abuse, RA 9262 also provides for the definition of a protection order. Protection order, as defined under Section 8 of RA 9262, is issued for the purpose of preventing further acts of violence against a woman or her child, and granting other necessary relief. Now, it must be noted that this relief can be requested by the victim of violence against women and their children, but it also allows other parties other than the victim to file a petition for a protection order. So this includes the victim's parents or guardians, their ascendants, descendants, and even relatives up to the fourth civil degree, certain officials and professionals, including a guidance counselor, law enforcement agencies, and responsible citizens with personal knowledge of the violence who may file the protection order. And in the list, while it is not mentioned that teachers and school administrators is obligated to report cases of violence, they are included with those of the responsible citizens who has personal knowledge of the abuse, as these kinds of abuses may also happen or manifested in schools and other educational institutions. What specific roles do the school play in the implementation of the Anti-Violence Against Women and Children Act? Now, one of the roles of schools is by educating students about violence against women and children. And by educating students, the knowledge and the learnings about the law and its implications is integrated into the integrating gender sensitivity into the curriculum, as well as establishing protocols for handling potential victim survivors and perpetrators. And they are also trained teachers and other teaching personnel on recognizing and assisting victim survivors, and develop school-based intervention programs for victims of VAUSI. Another important part of RA 9262 is the Interagency Council on Violence Against Women and Their Children, or the IAC-VAUSI. Now, this is established under Section 39 of RA 9262, which is composed of various government agencies. Among others is the Department of Education, of course, and the Commission on Human Rights. Now, what are the functions of IAC-VAUSI? First is to conduct training for teachers on how to handle children who are victim survivors on VAUSI in the home. Conduct gender sensitivity trainings and seminars for VAUSI. Develop a gender fair curricula at primary and secondary levels. Produce gender-responsive instructional materials, and integrate into the appropriate subject areas core messages on VAUSI by providing lessons that emphasize the social costs and implications of VAUSI. It also includes IAC-VAUSI also trained principals and teachers on the preparation of applications of a barangay protection orders, as they are also obligated, or they have the authority to file a BPO on behalf of the victim. And this is only when requested by the victim survivor or the barangay officials. The IAC-VAUSI also develop protocols for handling students, personnel, and teachers who are suspected to be victim survivors or perpetrators of VAUSI. And last but not the least, they are to establish school-based intervention programs for VAUSI.
Republic Act number 7610, otherwise known as the Special Protection of Children Against the Abuse, Exploitation, and Discrimination Act, was enacted to protect children from all forms of abuse and exploitation. Its provisions carry important intersections within the teaching profession and the practice of educational administration because they outline both individual and institutional responsibilities in maintaining child safety within learning environments. Section 2 of this act illuminates the state's policy to provide special protection to children from all forms of abuse, neglect, cruelty, exploitation, and other conditions prejudicial to their development. For educators, this provision emphasizes a duty not only to instruct, but to serve as active protectors within the school environment. It elevates the role of teachers from neutral observers to mandatory reporters responsible for identifying and intervening in any form of abuse that may affect their students. Section 10 of this act further defines acts of abuse and includes those listed under Article 59 of Presidential Decree Number 603 or the Child and Youth Welfare Code. This provision enumerates acts of maltreatment by quote-unquote parents, which is a term that broadly includes guardians and heads of institutions with custody of children. This thus encompasses teachers within its scope. It explicitly prohibits verbal abuse, excessive punishment, and psychological intimidation, which are practices that may have been historically tolerated but are now actionable under this law. For teachers, this means using positive and child-friendly ways to discipline and teach. And for school administrators, it means setting up systems to monitor abuse and handle complaints properly. In Section 27, it is not only the parents who are allowed to file complaints for children who suffer from abuse, exploitation, or discrimination. Teachers and other concerned individuals are likewise given the liberty to institute it. This is in keeping with the doctrine of in loco parentis, where teachers are seen as second parents while children are in school environment. To complement this, we have DepEd Order Number 40, Series of 2012, or the Child Protection Policy. This requires teachers and school staff to actively prevent and respond to child abuse by reporting cases and working with authorities. These assurances make it clear that educators are not mere observers, but they are legally bound to act as protectors with a duty to intervene and protect children when abuse is suspected. This responsibility goes beyond protecting children from abuse by adults. It also involves ensuring students are shielded from bullying by their peers. To address this, Republic Act Number 10627, or the Anti-Bullying Act of 2013, mandates that all public and private schools in the Philippines establish clear policies to prevent and address bullying. The urgency of this law is stressed by findings from the 2022 Program for International Student Assessment or PISA report, which revealed that 43% of girls and 53% of boys in the Philippines reported being victims of bullying at least a few times a month, which is much higher than the global average. This shows just how important teachers are in making sure students feel safe, respected, and supported within school environments. This law gives a broad definition of bullying, including not just physical violence, but also verbal abuse, emotional harm, cyberbullying, and social exclusion. This definition places a duty on teachers to spot both obvious and overt signs of bullying and know how to respond appropriately based on school policies. In many ways, identifying and addressing bullying is now a central part of a teacher's responsibility, even if it's not always explicitly stated. On the part of school administration, they are expected to adopt the anti-bullying policies and outline the minimum components that such policies must include. These are rules for discipline, ways to report bullying, and programs to support students. School heads and administrators are responsible for making sure these policies are in place and followed. And beyond implementation, they must also ensure that both the victims and the accused are treated fairly so that discipline is done with respect for every child's rights. As we know, prevention is just as important as response. The law thus mandates schools to run education campaigns, provide regular training for staff, as well as orientation for parents and students. This means teachers are not only responsible for handling bullying, but also for preventing it by teaching anti-bullying measures in the curriculum and school culture. If administrators fail to run these programs, they may be held accountable and could even lead to legal consequences if bullying persists or escalates. To support all of these efforts, DepEd Order Number 55, Series of 2013, further enshrines the roles of child protection committees in every school. These committees, which are often chaired by school heads and involving teachers, are the frontline enforcers of anti-bullying measures. Their functions, such as monitoring cases, ensuring its resolution, and recommending appropriate disciplinary actions, make the shared leadership between teachers and administrators indispensable for effective implementation.
The law was a product of a legislative inquiry after a hazing-related incident in 2017. It repeals the original anti-hazing law or Republic Act 8049 and imposes stricter penalties on hazing-related acts. It defines hazing broadly and prohibits all forms of hazing in fraternities, sororities, and organizations, whether school-based or community-based. It holds educational institutions, officers, and even parents or guardians accountable in certain cases. The Anti-Hazing Act upholds constitutional guarantees by protecting students from violence and abuse within educational institutions, ensuring a safe environment conducive to learning. Now, what is hazing? Under the Section 2 of the said law, hazing was defined as hazing refers to any act that results in physical or psychological suffering, harm, or injury inflicted on a recruit, neophyte, applicant, or member as part of an initiation rite or practice made as a prerequisite for admission or a requirement for continuing membership in a fraternity, sorority, or organization, including but not limited to padding, whipping, beating, branding, forced calisthenics, exposure to the weather, forced consumption of any food, liquor, beverage, drug, or other substance, or any brutal treatment or forced physical activity which is likely to adverse affect the physical and psychological health of such recruit, neophyte, applicant, or member. This shall also include any activity intentionally made or otherwise by any person alone or acting with others that tends to humiliate or embarrass, degrade, abuse, or endanger by requiring a recruit, neophyte, applicant, or member to do mental, silly, or foolish tasks. Now, what are the organizational requirements for fraternities, sororities, and organizations not created by the school but with student members or those intending to recruit students? All existing or newly established fraternities, sororities, and other organizations not created or organized by the school but which have student members or intend to recruit students must register with the proper school authorities before conducting any activity, including recruitment, whether on or off campus. This could be found on the Section 6 of the said law. They must also submit a comprehensive list of members updated within 30 days from the start of every semester or trimester. Failure to register or update the member list may result in disciplinary penalties, including suspension of officers and cancellation of registration. Now, what is the role and responsibility of faculty advisors in registered student organizations? And what is the legal presumption in case of hazing violations? Under Section 7 of the said law, faculty advisors are required as a condition for registration and accreditation of any fraternity, sorority, or organization. They must be non-members of the group and must consent in writing to their appointment, and advisors are tasked with monitoring the activities of the organization and must be active, recognized faculty members in good standing. And in case of any violation of the Anti-Hazing Act, it is presumed that the faculty advisor had knowledge and gave consent, thus potentially implicating them in the unlawful act. What are the penalties for hazing that results in death, and what liability do school officials have if they fail to act despite having knowledge of hazing? Under Section 14A and Section 14F3, if hazing result in death, rape, sodomy, or mutilation, those who planned or participated will face reclusion perpetua and a fine of 3 million pesos. And school officials, including faculty members, are liable as accomplices and can be held administratively accountable if they had actual knowledge of the hazing and either consented, allowed it, or failed to take preventive or reporting actions, provided that reporting could have been done without endangering themselves or their families. Termination of school personnel, whether academic or non-academic, must comply with both the Labor Code of the Philippines and specific education laws, primarily the Manual of Regulations for Private Schools. It is now embodied in the Manual of Regulations for Private Higher Educations, or MORFE, for colleges and universities issued by the Commission on Higher Education, or CHED, or the Department of Education, depending on the level of the school. The pertinent laws that covers the termination of school personnel are the following. 1, the Labor Code of the Philippines. Second, the Manual of Regulations for Private Schools, or the MORFE. Third, the Education Act of 1982, or the Batas Pambansa Bilang 232, and Republic Act number 467T, or the Magna Carta for Public School Teachers for public school personnel. Now, what are the grounds for personnel to be removed from office in an educational institution? Under Article 297 of the Labor Code, an employer may terminate an employee for the following just causes. 1, serious misconduct or willful disobedience. Second, gross and habitual neglect of duties. Third, fraud or willful breach of trust. Fourth, commission of a crime or offense against the employer, his family, or authorized representatives. And 5, other analogous causes. And under Article 298 of the same code, termination is allowed for authorized causes, such as 1, installation of labor-saving devices. Second, redundancy. Third, retrenchment to prevent losses. And lastly, closure or cessation of business. However, under the Manual of Regulations for Private Schools and CHED's MORFE, the following are the valid causes for termination. For academic personnel, 1, gross inefficiency or incompetence. Second, dishonesty or immoral conduct. Third, neglect of duty. Fourth, conviction of a crime involving moral turpitude. Fifth, a violation of school rules and regulation. And 6, physical or mental incapacity. And lastly, other just causes analogous to those listed under the Labor Code. And for non-academic personnel, there's only one cause, which is that causes for termination are primarily governed by the Labor Code, but school policies also apply. Is there a process that needs to be followed in order for a person or personnel be removed from office? Both under the Labor Code and educational regulations, termination must observe procedural due process. And for just causes, there must have been the presence of the 2 notice rule. First, which is the notice to explain, which is that the informing of the employee of the charges, and lastly, the notice of the decision. It happens after allowing the employee to respond to the notice to explain. And for authorized causes, a 30-day prior written notice must be given to both the employee and the Department of Labor and Employment.